Okay, so hi, today I shall be discussing a case regarding interim maintenance, but this case happened during COVID-19. It is a case regarding domestic violence abuse where the petitioner, that is Megha Khandelwal. The case is about Megha Khandelwal versus Rajat Khandelwal, where after facing domestic violence she and domestic abuse, the petitioner Megha Khandelwal filed a case under section 12 of Protection of Women from Domestic Violence Act 2005 seeking interim maintenance for herself and her minor child, and the trial court awarded rupees 5,000 initially to her, and dissatisfied with this amount on appeal the session court enhanced the awarded amount to 9,000. That is around 6,500 for herself and 2,500 for her minor child. Now dissatisfied with this amount, Megha Khandelwal challenged this appeal in the Rajasthan High Court, where they dismissed the petition on the ground saying that her qualification was enough for her to maintain herself, as she was MSc in biotechnology and she was pursuing PhD, so she is capable of earning and she can support her child. This way the Rajasthan High Court had dismissed her petition, so she challenged the decision at the Supreme Court, where the Supreme Court, after reviewing the documents and all other submissions, the Supreme Court held that alone the educational qualification of women cannot disentitle her from receiving adequate interim maintenance. So the appeal was whether the earning capacity or education alone can disqualify a woman from receiving adequate interim maintenance under Domestic Violence Act. Now I shall be explaining what is interim maintenance and what is alimony. Interim maintenance એ હોય છે જ્યારે ડિવોર્સ કેસ ચાલે ત્યારે જે ડિવોર્સ કેસ ચાલતો હોય ત્યારે જે સ્ટ્રોંગ ફાઇનાન્શિયલ પાર્ટી છે એ વીક ફાઇનાન્શિયલ પાર્ટીને ટેમ્પરરી ફાઇનાન્શિયલી સપોર્ટ કરે ફોર ધ બેઝિક નીડ્સ લાઇક ફૂડ, શેલ્ટર, મેડિસિન. And alimony is a interim maintenance is a temporary financial support and alimony is a permanent financial support, that is after post divorce, જ્યારે ફાઇનલ ડિક્રી પાસ થઈ જાય કોર્ટથી ડિવોર્સની એના પછી જ એલિમની પે કરવાનું હોય. એલિમની ઇઝ અ લોંગ ટર્મ ફાઇનાન્શિયલ support and it is paid in a lump sum amount at one time or monthly भी pay करवानु होय for a long period of time. That is all decided after the final decree. Now for deciding the interim maintenance and alimony, various factors are taken into consideration. Interim maintenance is decided under section 24 of Hindu Marriage Act 1955, whereas alimony, that is permanent financial support after the divorce decree is passed, is decided under section 25 of Hindu Marriage Act. But even the interim maintenance is decided under section 125 of CRPC for quick relief, which is now replaced by section 144 of BNSS 2023, that is Bharatiya Nagrik Suraksha Sanhita, where they have replaced the minor child word with the adult child, that is not capable of earning can also claim maintenance along with the wife, child and parents. Okay, so this is the difference. And now the factors that are taken into consideration while deciding interim maintenance by the court are that, like one of the case in 2021, that is Rajnesh versus Neha, where you have to attach an affidavit in a particular uniform format with the disclosure of all assets and liabilities of both the parties to ensure the transparency. And other factors are like health, age, earning capacity, employment capacity, then the duration of marriage, and the financial support and non-financial support by both the parties during marriage. The factors like કોને છોકરું મોટું કર્યું અને કોને કરિયર ગીવ અપ કર્યું, everything is taken into consideration while deciding the interim maintenance as well as alimony. Okay, so now the Megha Khandelwal versus Rajat Khandelwal case that we are discussing, the judgment was that the Supreme Court granted leave and entertained the appeal against the High Court order of rupees 9,000 interim maintenance, and Supreme Court held that alone the educational qualification of women cannot disentitle her from getting interim maintenance because she has that earning capacity. But currently in this case she was not earning and had a minor child to support, and the another judgment that was made by the Supreme Court in this case was that the amount that is fixed by the lower court was inadequate, and the lower courts cannot just on the basis of documents and submission fix inadequate amount or suppose an adequate amount, but they should take into consideration the practical factors as well. And the Supreme Court enhanced this interim maintenance to rupees 25,000 effective from 1st May 2019, that had to be paid on the 10th date of every monthly calendar until the final judgment is made in the main proceeding. And then the court also ordered the trial court to endeavour to dispose of all pending related cases, that is FIR, complaint, divorce petition between both the parties with the support of both parties within 6 months, and all the appeal were disposed of and pending application was also disposed of. Now the impact of this case is that the interim maintenance that is awarded should reflect the need of the aggrieved person, that is the basic need during the divorce period. The basic need, that is જ્યારે divorce case કોર્ટમાં ચાલે છે ત્યારે interim maintenance should reflect the need of aggrieved person, that is her basic need is food, medicine, shelter, those things. And the second thing is that it reinforces the timely disposal of pending litigations like FIR, complaints and petition, so that there is no undue delay in the primary rights and relief of the parties. And it contributes to the jurisprudence emphasizing that the Domestic Violence Act's protection and relief maintenance should be meaningful and effective, and it should just not be symbolic or minimal. And it also the impact was that even though the lower court has given a proper adequate interim maintenance, but if the High Court feels that the lower court નું જે interim maintenance amount fix કર્યું છે એ adequate નથી, તો High Court can enhance it. This was the impact of this case. Now maintenance, ઘણા બધા પુરુષોના મગજમાં એવું હોય છે કે I will not pay maintenance whatever happens, because એ લોકોનું કારણ હોય છે કે સાસરે નહોતી રહેતી, કે ઘરે એને મારપીટ કરી છે સાસરામાં કોઈ સાથે, છોકરાઓને નહોતી રાખતી, ઘરનું કામ નહોતી કરતી, whatever, પિયર જતી રહી છે. બટ ઓન ધીસ બેઝિસ એક પુરુષ એવું ન કહી શકે કે હું મેન્ટેનન્સ નહીં આપું. બટ અગર એ પુરુષ કોર્ટમાં પ્રૂવ કરે છે કે અડલ્ટરીના બેઝિસ પર કે ક્રુએલ્ટીના બેઝિસ પર, ડેઝર્શનના બેઝિસ, this basis he has to prove in the court, and once it is proved in the court, then a maintenance na ape to chale. But for one default there is the 30 days the jail. One default in the payment of maintenance, there is 30 days of imprisonment. And see, actually in maintenance and alimony both the cases, it is that લગન બેવ કરે છે, but the court has ordered that when you have to pay the interim maintenance or alimony, તો પુરુષ ત્યારે એવું કહે છે કે મારી પાસે અત્યારે I am not earning well, મારી જોબ છૂટી ગઈ છે, whatever, I am not capable of paying the maintenance that she is asking for, or alimony that she is asking for. તો કોર્ટે એવું કીધું છે કે પુરુષોએ ઓવરટાઈમ કરવું જોઈએ, મજૂરી કરવી જોઈએ, ઈંટથી મકાન ચણવાનું કામ કરવું જોઈએ, but he has to pay the maintenance or alimony to the wife. And because it is impossible કે વાઇફ પાસેથી તમે મેન્ટેનન્સ કે ઇન્ટરિમ મેન્ટેનન્સ કે એલિમની લઈ શકો, that is in rare case, that is like purchasing a white elephant, it is that rare કે એક પુરુષ એની વાઇફ પાસેથી ઇન્ટરિમ મેન્ટેનન્સ કે એલિમની લઈ શકે. So this Megha Khandelwal versus Rajat Khandelwal case was regarding interim maintenance, that is under section 24 of Hindu Marriage Act 1955. And another relief is that I mentioned, 125 CRPC is for quick relief. That is now section 144 of BNSS 2023. Now the another thing is that after this case, the question arises, what is the main difference between interim maintenance and alimony? Alimony is a lifetime financial sustenance after the divorce decree is passed. That is post-divorce arrangement of financial sustenance to the ex-spouse. And interim maintenance is a monetary relief to the spouse during the divorce case, and interim maintenance is monthly paid, and alimony is one-time payment, that may be lump sum, monthly paid for a long period of time, or for like a period is set, mostly it is for a long period of time. And I told the factors જે consider કરવામાં આવે છે. Now what happens that in many cases it happens that execution petition is filed by the wife after the final court decree is passed in the divorce cases, where execution petition is filed when the winning party actually it happens when the losing party does not comply with the court's final decree order. That is, it doesn't pay the monthly that is, it doesn't pay the awarded alimony amount that is decided by the court, or doesn't જે કોર્ટે ઓર્ડર કર્યું હતું ચાઇલ્ડ સપોર્ટ માટે, અથવા તો પોઝેશન ઓફ એસેટ્સ માટે, અથવા તો જે કોર્ટે ત્યારે ઓર્ડર કર્યું હતું પ્રોપર્ટી ડિવિઝન, પ્રોપર્ટી અટેચમેન્ટ, આ બધા સાથે જ્યારે લૂઝિંગ પાર્ટી કોમ્પ્લાય નથી કરતી ત્યારે જ વાઇફ એક્ઝિક્યુશન પિટિશન ફાઇલ કરે છે, so that she can realize the relief that is rewarded, that is the winning party. જ્યારે એ ડિવોર્સ કેસ જીતી જાય છે પણ સામેવાળી પાર્ટી એ કોર્ટના ઓર્ડર સાથે કોમ્પ્લાય નથી કરતી, ત્યારે આવી રીતે એક્ઝિક્યુશન પિટિશન ફાઇલ થાય છે, and that is under the CPC order 21. Now in these cases the court orders the losing party to pay alimony at this fixed amount, or to do these things for the child support, to the seizure of assets, that is seizure of assets, that is, and another is garnishing of wages, garnishing of bank account, and in many cases when then too the losing party does not comply, then it happens that there is a civil arrest that happens and warrant is issued, and there is freezing of bank account, there is seizure of assets. These things happens when the losing party still does not comply with the court order after the execution petition is filed, and that petition has to be filed in that court only, the court which has passed the final decree of the divorce, and the limitation period is within 12 years of the from the date of the decree is passed. Now I will tell you what is plaintiff and petitioner no difference. Plaintiff and defendant are both in civil as well as criminal cases. Plaintiff and petitioner are the one that initiates the legal action. Plaintiff is the one that files a lawsuit when he thinks that wrong has been or damage or harm has been caused to him, and he files the case for a civil remedy. And when the plaintiff wins the court case at the trial court, the judgment is passed against the defendant, where most of he has to pay the monetary damages, compensation, injunction, that is to do something or stop doing a specific action, or either it is the court passes the order of seizure of assets and garnishing of wages, bank account garnishments, liens. These are the orders that are passed. Now, when does the plaintiff becomes petitioner? જ્યારે plaintiff lower કોર્ટમાં હારી જાય and એ હાયર કોર્ટમાં અપીલ કરે છે for the remedy or to review the case, then that person becomes petitioner. That is, the plaintiff becomes petitioner on appeal in divorce cases, in the property cases. In such cases, plaintiff becomes petitioner. And defendant is the one, even in criminal cases, defendant is the one who is accused of committing the crime and is prosecuted by the government. And in criminal cases, the defendant, the procedure starts from that complaint is registered, FIR, warrants are issued, charge sheet is framed, and then he gets arrested. There is the cross examination, counter claims, everything, and finally in criminal cases there is the sentencing and punishment for the defendant. Now, when the defendant becomes a respondent when a petition is filed. Okay, when a petition is filed against that person, the defendant becomes a respondent, and in criminal cases the plaintiff is called the people, the state, on behalf of victim. This is the difference between the plaintiff and petitioner, defendant and respondent. And yes, the alimony that is decided by the court is for lifestyle equalization. That is, it takes into consideration the lifestyle of the spouse in her matrimonial home as well as her lifestyle in her parental home. So this is also one of the main factor that court takes into consideration while deciding the amount of alimony. So this is what is for today, that interim maintenance is the education is not income and dignity isn't optional. So though she was very well educated, Megha Khandelwal, the Supreme Court enhanced her interim maintenance from 9,000 to rupees 25,000 monthly until the final court order was passed in the main proceeding.